si.com. We appreciate getting phone calls from parents out there that's having problems with the DHS. We try to help on a one-to-one basis. My number is 276-3956, and John's number is 282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. We're only too happy to assist in whatever way we can. We're not lawyers, so we can't respond to your legal requests, but we can give you some hints as to how you should proceed on your own to meet up with some of the problems that plague your family from the Department of Human Services or the juvenile court. There seems to be a lot of talk about abused children, and we kind of wonder if this isn't being overdone by a system that profits and expands and maintains large staffs because of the perception of high abuse reports. And one of the things that's somewhat worrisome now is that we are trading money coming from federal government to state government in order to encourage more and more abuses of the system. Actually selling children, actually taking children from some families, putting them in foster care, and then adopting them out to other families in order to protect them, so-called protect these children. Well, one of the things, one of the major shifts in state government is a concentration of efforts of the Department of Human Services on children whose ages is 6 and under, because we find that they are probably the most vulnerable of children, and DHS has determined that they need the most protection from an agency. And Don's going to bring us a story about the new response for abused, neglected kids under age 6. This comes from the files of the Department of Human Services. So it's their story. Don?
Okay, John. It starts out. It's written by Jennifer Jacobs. She first says, "Removing a child from everyone he knows and loves can be an experience akin to kidnapping." When a child abuse investigator took Kathy Green's grade school son, she felt like an explosion rocked her family. This was a Des Moines Register article a week or so before you're hearing this program. She goes on, "Out of nowhere, boom, a bomb hits the ship, and you are so dazed you can hardly see straight," said Green, a stay-at-home mom from Larmer. "It's really a sick feeling." A teacher at the elementary school had reported that Green's child might have harmed his younger sibling. The investigator interviewed Green and her children for 4 hours December 2nd, then decided that to protect the other children, the boy should go to an emergency youth shelter. Green and others say the state is too quick to yank children from homes where abuse or neglect is suspected. Federal statistics appear to show Iowa resorted to foster care more than any other state in the country in 2003. The state's rate of removal was about 3 times the national average. Not counting these cases, however, Iowa still ranks among the top 5 states for removal. If a child is returned home but bounces back into the foster system within 6 months, Iowa counts it as 2 removals. So they get a double statistic there. And there is no denying that Iowa has one of the worst records on children re-entering the foster care system within a year of returning home to their families. That happens to about 25% of the children, Munn said, and he reports for the DHS. Children's advocates say it's clear Iowa must do a better job at helping parents as they struggle to care for kids at home. Removing a child from everyone he knows and loves is enormously traumatic for that child, says Richard Wexler, Executive Director of the National Coalition for Child Protection Reform. It can leave lifetime emotional scars for a young enough child. It can be an experience akin to kidnapping. And also, we know statistics show that when DHS gets their hands on kids, a lot of those kids end up, when they turn 18, they are thrown in prison. Good training by DHS. Mary Nelson, who oversees the system that helps abused and neglected children, said Iowa's removal rate is not out of sync. Iowa's court removes children from their homes only under the most extraordinary circumstances when there's imminent risk of serious harm, she says. And even then, reunifying the child with the family is a top priority. And that just makes me sometimes laugh at some of those things. The majority of the people out there in the public don't realize what DHS is doing. This article continues on. When the number of children in foster care was counted on a single day in 2003, Iowa ranked in the middle among Midwest states. A federal review last year found Iowa does a good job with vulnerable kids in several areas, keeping them safe while in foster care, not moving them among more than two foster homes, returning them home in a timely way, or if that's impossible, finding them an adoptive home quickly. Well, I'm not sure. Maybe things have changed a little bit since the last statistics I saw. But last memory I know is that children end up in approximately 16 foster homes before DHS finally gets what they want and terminate the parents' rights. So I believe the statistic is way too low, saying that they only are in 2 foster homes. Well, I don't care how many foster homes they're in. 1 foster home is too much for a child. What did that child do to deserve foster jail? Let's skim down here and hit 2 or 3 more comments. Kari Kurtz of Waterloo knows the pain. She said she was arrested for arguing with a social worker and police officers who came to take her grandchildren away. Well, even grandmothers love their kids. What is she supposed to do when she believes something is going wrong? Downs can identify with the families. Her grandchild was taken away from his parents when money troubles led to drugs and domestic violence in January 1993. Her grandson ended up in foster home on a regimen of medications that would knock down an elephant. How many times have we reported about all these medications that the kids are pumped into? I didn't recognize the child that came out of that nightmare, Downs said. He just wasn't the same anymore. And there are times when parents can't even control their own children, thanks to the training of DHS. Public opinion has been a pendulum. In the late 1990s, there was an outcry over parents being wrongly accused of child abuse. Okay, John, you got something else?
We're going to get back to some of those articles. One of them was that one that I thought you were going to pick up, the new response to abused, neglected kids age 6 and under. And we'll also talk about why it is that the state insists on adopting more and more children out. Why it is they want to steal children and then brag about what it is that they're accomplishing. Well, I'll give you one hint. is something called welfare program bonuses. You give somebody a bonus to do something, and if they have no scruples about stealing children, they'll go ahead and do it. And it's, they don't have a whole lot of inhibitions like the bear in the woods that dips his paws in the honey pot. They just cannot keep their hands off. And as long as there's money there, there's going to be somebody who is willing to pick up that money. Well, we're going to talk to somebody here in just a moment who has been doing a lot of background research in the courts. That's where some of these things need to be taken in order to get some relief for families. The gentleman we're going to be talking to is Terrance Walker with an organization or a website called A Matter of Justice 2003 at yahoo.com or vejo.org or A Matter of Justice, www.amatterofjustice.org.
He used to be a guest on this program, didn't he,
John? Until he turned into a consultant for the program. So no longer a guest. Here now, Terrance Walker.
All right. Well, thank you. Appreciate the invitation to be here as a regular now. I had to relate what I have to say to what you're discussing right there. I mean, like I always say, the courts are responsible. If we've got a piece of legislation that's written by the legislators that is the blame, then yeah, we can blame the legislators. But in a lot of instances, we have in place legislation that should protect citizens and families from these type of abuses, and it is up to the courts to start interpreting those provisions and in accordance with these other measures, because all citizens, we do have protection. We have constitutional protections that should not be usurped by these legislative initiatives to have kids just taken out of the homes and used as basically tools to get more money for the state and to state coffers. I had to break off into what I was going to discuss here. I had the pleasure yesterday of going to the oral arguments at the Iowa Supreme Court for the change in ethic rules for attorneys and prosecutors, and I find it was very entertaining, but at the same time,
entertaining.
Yeah, it was just entertaining. The level of insanity that goes on within the legal I want to say legal industry. Can we say legal industry? Does that make sense?
Sure.
Legal occupation, whatever you want to call it.
Parlance would be the.
There you go. whatever you want to call it.
Okay.
It's a lot of insanity that goes on within that. Well, to give you a backdrop as to why they had oral arguments at the Iowa Supreme Court yesterday. Well, the Iowa Supreme Court proposed a couple years ago that they were going to change some of the ethic rules, and they made further proposals in the wake of a scandal that happened in Cass County that to make the prosecutors also subject to the new rules and new changes for the ethic rules. And then they was going to also have one centralized board to review complaints against prosecutors and also attorneys. Now they're not proposing anything against any judges, unfortunately, which is my main beef. But to get back on point, a number of county attorneys associations had complaints about these new changes. I just found it to be, and this is some of the insanity that transpired yesterday. Fred McCoff, I believe that was his name, of the County Attorney Association. He was the one that spoke first to the Iowa Supreme Court regarding these rule changes. He, along with several other of his colleagues that were also prosecutors, are affiliated with prosecutors associations, were of the opinion that the board needs to let the local prosecutors or local cronies oversee the complaints. When asked how many complaints that the prosecutors or county attorneys association have received statewide, the number was something like 60 complaints a year, which, when you think about it, that's not a whole lot of complaints. This was set up in 1977. The County Attorneys Association was to review complaints and train prosecutors. This Fred McCoff was 12 years on the committee. Judge Michael Straight says, why refer groups to county attorneys when why refer these complaints to groups of county attorneys when other attorneys don't? And I guess the argument that was being, or his point he was trying to drive home, was that, you know, why not have, if we're going to have different bar association or different complaints reviewed by different attorneys or the same attorneys, why not have one for commercial attorneys, one for criminal defense attorneys being reviewed by criminal defense attorneys? You know, and it just brought home the insanity of what he was trying to claim, along with the rest of the people. Doug Merrick, I believe, of the Iowa Attorney General's office, was up next. And he said, along with the other attorneys, county attorneys and stuff, we're also saying that the current system is working well, and many of the complaints can be dealt with locally on a more efficient level. Now, again, we're talking 60 complaints a year statewide against county attorneys. And he's also wanted to encourage the use of local committees and have their rules approved by the board, which was a statewide board. Or actually, no, Judge Wiggins of the Iowa Supreme Court said that would he have a problem with the main board deciding the local board's rules? And to that, he said he supports some sort of uniformity and transparency, and kind of didn't really answer. What was you going to say, Don?
60 complaints a year.
Yeah.
Doesn't that sound a little low, or is that because majority of people don't realize that they can file a complaint?
Well, see, the problem is that you've got to go through a lot of hoops and hurdles to find out where to complain to. First off, for the average citizen, they don't know they can complain to the County's Attorneys Association. My experience with the County's Attorney Association was actually validated when I was hearing these some of these responses of what they were talking about as to how efficient they are and how well the complaint process is. If you were listening to them, they were contradicting themselves, because they were all saying how, well, we're there. It's just an enormous amount of work, and there are only 60 complaints a year. Come on now, statewide, a board, 2 or 3 people can handle that, unless you're doing a lot of work. Well, it didn't seem like they were doing a lot of work, because the guy for the I think it was the Attorney General. Yeah, well, he was also from the Attorney General's Association. Basically said that the number of complaints here, and I have a specific number. David Grace of the Professional Ethics Board, he said that 90% of the complaints that they get are disposed of quickly. And he said 70% are dismissed immediately. So when you think of the number 60, and you think of 90% of those, that leaves about 6 complaints that they really put a little bit of time and effort into. And what was you going to say, Don?
I think you used the word figure 90% or something like that. That I believe they just send out a form letter and tell you that, hey, you filed a complaint in the wrong area. You got to go someplace else. Even though this is a county attorney's complaint place, you got to go someplace else. Don't you see that way? Very simple.
What I felt about the whole County Attorneys Association was actually confirmed when one guy came up there and basically said that what did he say? He said they get two types of complaints. It was Fred McCall for the County Attorneys Association. They get people that are unsatisfied with the result, and they usually don't understand prosecutorial discretion. Okay, that was the one type of complaint that he said that they get. And then the other complaints they get are boxes of complaints from penitentiaries from people that have been convicted, and they send in their whole entire record and complain. And he didn't say that there was any third types of complaints they get, like, for instance, ones that are valid.
Or legitimate, yeah.
Hello. So what I was thinking about the County Attorneys Association was actually confirmed when he made those comments that there were two kind of complaints. And he did not even he didn't even list the third kind of complaint, one that could be legitimate, which I'm sure there's some that are there. One of the good guys that actually came up and spoke and made some he was basically against the grain of everybody. He was from what office was that from? He was from the Public Defenders Association. He made clear that his boss, Tom Becker, said to tell the court that he doesn't represent us. Tell the court that. So he made that perfectly clear at the onset, because I guess there's fear of reprisals from this gangsterism mentality that's within the court system. You can't say anything against the grain or else you're going to be out of a job type of mentality. But what he was saying was that justice is perceived. Prosecutors will perceive justice like prosecutors, and criminal defendant lawyers will be perceived justice in another way. So it really doesn't make sense to have people of a similar thought pattern to analyze complaints about you. If this prosecutors' complaints are going to prosecutors, they're going to think like the prosecutors and be basically effectively act as cheerleaders for those prosecutors. And he countered what all the other attorneys were saying, that the board, that the County Attorneys Association was essentially effective beforehand, because he cited one case involving Paul Green, and this was a February 9, 2005 case where a prosecutor basically claimed that he said this in court, which was very unethical. He called some of the witnesses that the defendant had on trial or had for him liars, and he had done it before too. And Steve Japutnik, who's bringing this out, he cited the other case where Paul Green had done the same thing. Well, he goes on to state that, this guy has never been sanctioned by the County Attorney Association or anybody. So, here we got two very popular cases. They've been cited in legal opinions. Same guy, same thing that he's doing wrong, and he does not face any sort of negative actions for his unethical behavior. And then he also goes on to state, Steve Japutnik does, at the oral arguments yesterday, that attorneys are afraid to speak out for fear of sanctions. But he spoke out anyway to the Des Moines Register. And, we got to applaud attorneys like that because they're far and few between. There are evidently few legal people with spines these days. They're all in fear, it seems, of the establishment, if you used to say. Well, they should be in fear of us losing our rights, but I can understand why they would be in fear, because it's a very private and secretive run community, legal community. They've got secret boards. secret complaining procedures. The judiciary complaints, we don't know. We still don't know how many complaints are filed a year against the judiciary or the judges on there. And heck, since 1972, I believe, or 75 which was when 72, since when the Judicial Qualification Commission was set up, we have only had a handful of judges removed by them. So, who's to say that it's working? We don't know. But, I would surmise that if everything's so secret and hush-hush and we don't know anything of what goes on, and we've only got a handful of judges that's ever been removed, I would suspect that there's a lot of cronyism going on. And heck, I would like to be judged by some of my friends if I was to face some sort of negative action against me, and I could decide who is going to be there to judge whether or not I did wrong. Heck, wouldn't you want to have some friends of yours judging whether or not you're deciding your fate? So I mean, these are people that are supposed to be ethically bound to determine justice, and yet they cannot see the fault, or they supposedly cannot see the flaw in having their own cronies assess the worthiness or the lack of worthiness of their actions. And this is what we are up against with this establishment. And it's too bad that we don't have more lawyers like Steve Japutnik, and it's too bad that we don't have more judges like Justice Wiggins, who actually was the only one that I could see that actually questioned these prosecutors on the lack of the illogicalness of what they were proposing. Was that we should farm out all these complaints to the local people so that their cronies can assess whether their actions are right or wrong. Like I said, was insanity. And I wish you guys could have been there. It was just insanity to witness this whole event.
It sounds like you're talking about the story of the noble fox. There are probably lots of noble foxes and foxes that you could trust. Right?
Exactly.
Especially when there's a chicken house around.
But you don't set them in charge of the chicken house. And I think of this as in the same fashion as I think of audits. A good audit plan for a corporation or for a small business or whatever else makes the assumption that everybody is a thief, and you don't put the bank president's daughter in as head cashier, for an example.
Yeah.
Not that she isn't trustworthy, but it just isn't good audit procedure to do things like that, and to set the fox in charge of the chickens. I don't think is a really a noble practice, and
it doesn't make a whole hell of a lot of sense. That's the thing that really rings in my head when I was listening to this. Like, well, these are the guys that are supposed to be seeking justice for us all here in Iowa. Okay, now they cannot see the lack of logic in having their own cronies assess their actions, assess whether their actions were proper or not. I mean, come on now. They argue, I'm sure, day in, day out in court against this type of thing. Of course his friends are going to come and testify for him because they're his friends, And yet, when it comes to them, well, they're high and mighty. They're above those standards. And there was one lawyer in particular that really he made me almost puke. This guy was representing the Iowa State Bar Association. And he went on for close to 5 minutes of his 10-minute presentation talking about how great the judiciary was and how great the lawyers here in the state are. And he just knows this. He just knows this to be true. And he just feels it within his soul. It was just it was just a very sickening thing to even watch. This guy was. Can I say the word ASS, or maybe I'll just spell it? Okay, he was kissing a lot of ASS to
Sure.
make it short and to the point. But yeah, Justice Wiggins and Justice Strait was the only two judges that actually questioned the illogicalness of all they were proposing to farm out all this stuff, all this work, 6 cases that are actually going through thoroughly, and I don't know how thoroughly they're going through these 6 cases, but 6 cases a year, and they got to farm all these out to the local officials so that they can handle this so burdensome of a task. I just found that was just unbelievable.
I wasn't there, but to view all this stuff. But when you talk about how brilliant and how ethical these prosecutors are, it seems to me that you may have viewed angel wings fluttering there and messing up the paperwork, because one would seemingly draw from your lecture so far that there's nothing that these people do that is wrong, and if it was wrong, it could be well straightened up by their colleagues, whose angel wings are always in view.
Well, I think they're more concerned with the appearance of propriety than they are with the actual implementation of propriety, because that's all that it's going to concern is the appearance of propriety. Of course, it'll appear that nothing's going wrong and nothing's happening that's unethical when you have a bunch of people judging themselves and their cronies of assessing their actions.
I may ask you a question about a local prosecutor and about his habits, and then see if you can tell me how either a local board or a centralized board could conduct a thorough investigation and determine whether or not he should remain in office, or if he should even keep his license as a license to practice his craft.
Yeah, well, would that be Justin Allen?
That would be Justin Allen.
Yeah, well, if they had it their way, then Sarcone would be assessing his worthiness, or
that's right.
Might not even be Sarcone. It might be one of his underlings doing the work, and they might just meet with him privately for a few minutes and say, "We're just going to shove this under the table."
Maybe I should pose that problem. Here's a county attorney who knows the Iowa rules of criminal procedure. He knows the paperwork thoroughly, and he knows the judges. He knows the deputies, and he believes everything he hears, every complaint that he hears. And he decides to initiate a criminal action as a simple misdemeanor. He knows that 2.54 of the criminal code requires that criminal action be preceded by a sworn-to statement. He looks at the paperwork. He sees no criminal action there, or sees no sworn-to statement, but he goes to a pre-hearing. Then he goes to another pre-hearing in which the defendant says, there was no sworn-to statement. I challenge the jurisdiction of the court to act. And then he gets 2 judges to say, yeah, there were sworn-to statements, or no problem here with jurisdiction. And then he goes to trial. And before trial, the same question is raised. There's no jurisdiction here, Your Honor. The sworn-to statements are not in the record. But then the third judge says, yes, they were. There was a sworn-to statement, and it came out in writing. And we'll see that in just a moment if you want to read that in a little bit, Terrance.
Yeah, I'd like to see that.
And a reference was made to a Supreme Court case called City of Cedar Rapids versus Hattinger, and they only had 4 years to look over that case and to determine whether or not the Iowa Supreme Court was correct in its ruling. And they didn't change their paperwork. They didn't change their procedures. And when Justin Allen appeared in court, he said, if the court holds us to that Attinger case, we are in trouble because we have never we have never dealt with the sworn to statements. Now here's a man who is paid by Polk County taxpayers, and I believe they get money from the Iowa Treasury as well into the justice system. And he's gone time after time after time to court. He hasn't bothered to file any briefs. He hasn't bothered to file any resistances. He simply goes before the court and says, yes, there's no problem here, Your Honor. We don't want to file briefs. We don't want to get into the messy part of this. And so they go through a jury trial, and the facts of the case show that the individual, the way they manage it, the individual was guilty of violation of 719.1, somehow guilty of violating an officer by willfully and knowingly obstructing his official duty. Well, that was was appealed, and then the same Justin Allen, several months later, goes back to court and says, well, I decided that Cedar Rapids versus Hattinger was correct after all. Several months later,
Several $100 later,
and several $100 later, and an awful lot of work.
Well, that's just your expenses, though.
That's right.
That's not the expense of the judge for a day.
Correct.
And the expense of a prosecutor for a day, and the expense of
and loading up
jury fees,
the docket. Loading up the docket and so forth. So what should we do under this proposal that you were looking at? What should we do with Justin Allen? Should he be put before his local people who will come after, who know that other people will come after them if they raise a voice against Justin Allen, or should that be turned over to some centralized, impartial authority to determine just how long it should take Justin Allen to study a case?
Yeah.
Is 4 years enough time to study city of Cedar Rapids versus Attinger? And when they say you shall have a sworn to statement, does that really mean that you have to have a sworn to statement in support of a simple misdemeanor?
I'd like
Terrance?
to answer that. I think that he should be dealt with very harshly because you have your rights basically ignored for several months. You've had to go through the arduous process of not only defending yourself, but researching the law, presenting the law, and presenting the facts in court. So he should not be given a free ride and allow the court just allow anything and everything to just go just because the prosecutor does not object to it going. And I would add that it did not appear that the judge or the prosecutor bothered to even look up any of the citations that you were citing to until after the case, which I think implicates not only the prosecutor but the judge in the case. And moreover, with the ruling that the court made, which was blatantly in violation, which blatantly misstated the facts, I think the judge should be implicated as well in some sort of disciplinary measures. And I've seen this all too often, where a court misstates the facts and blatantly misstates the facts. And hell, the judge would not even let you present testimony from the officer to show that he did not issue a sworn affidavit in regards to the reason why he was arresting you, which is a clear violation of the Iowa Constitution, which was the document that was the founding document for the state, which is over 150 years old. So, this is fundamental law. This is something that we should not be deviating from. And in conjunction with that, I'll read again, as I read last week, The Ultimate Injustice When a Court Misstates the Facts by Anthony D'Amato in a law review argument or article, Cardozo Law Review 11, Cardozo Law Review 1313 is a 1990 law review article. He paraphrases in here and cites. He says that even demonstrably false things can be stated as factually accurate in a judicial opinion because the reader typically will not question the accuracy of what a judge reports as facts. And we encourage glibness, we penalize honesty, we applaud fabrication, we discourage sensitivity of justice. We tell our students, they're talking about law students, that it is not the attorney's job to make judgment about right or wrong, but rather to represent the client irrespective of right or wrong. And he goes on to state furthermore that they feel that their work is subject to the whim of judges who play God with the facts of a case, changing them to make the case come out the way the judge desires. And this is not only the case in your case, but it's the case in which I was involved. Do you happen to have that copy of that order yet? I was gonna put that on there.
Order
Yeah.
in my case.
Yeah,
I'd have to sift through all
Okay.
my paperwork.
Well, I'll
here.
just go ahead and discuss
Okay.
my case here real quick, if I can paraphrase this. I had a case in 1996. It's been about 8 years ago. It emanated from a simple misdemeanor matter in which I was involved, which I was exonerated for having my First Amendment rights curtailed by a police officer who wanted to arrest me for a violation of my First Amendment rights. Well, excuse me, but I do know my rights. I've known my rights for a long time. So, but yeah, to make a long story short, I had a 12-year-old kid that I subpoenaed to testify in my matter. I had the paperwork prepared the day before I was going to give him the subpoena. I was going to give him the subpoena the day before the trial. I did not give him the subpoena the day before the trial. I gave it to him the next day. Well, I didn't have time to change the paperwork. I submitted my subpoena to the court and told him that I need my 12-year-old witness to come and testify. Well, the judge, seeing that I did not complete the paperwork as according to rules, and he basically, this was Judge Van Merrill out of Story County, he basically denied my subpoena. He denied to bring the witness in because I did not give the subpoena to the parents as required, and did not state that I gave the parents the subpoena. Well, because I've complained to a couple judges, and this is what we're talking about, judicial gangsterism. Because I complained to a couple of the judges concerning the case in Story County and surrounding their actions involved in the case. Well, the prosecutor obviously got together with the judge, and they decided, well, this subpoena sounds to me like this subpoena that he brought in could be criminal because it had the wrong date. He put the wrong date on there. He didn't give the subpoena to the guy, to the 12-year-old that day. He gave it to the next day. Now, this was irrespective of the fact that the subpoena was not valid in the first place because I didn't give it to the parents. But they trumped up 2 charges against me, perjury and tampering with records. And to go with my point here, to wrap this all up, they were supposed to prove that I was under oath for purposes of perjury. Well, this is what the law people, legal establishment does here in Iowa when you have cronyism. they changed the meaning of what an oath meant. And you can look this up if you don't believe it. 574, Northwestern Reporter, second series at page 280. You can go look that up at the Drake Law Library, the State Law Library, or any other law library, county law library, if you have some access to some books. 574, Northwestern Reporter, second series at 280 is a 1998 Supreme Court case. And John, Don, if you could put those documents up, I just want to make a reference to the first one here. This is what they said in the opinion. Now we're talking, I'm going to go back to this law review article. Even demonstrably false things can be stated as factually accurate in a judicial opinion because the reader typically would not question the accuracy of what a judge reports as the facts. This is what your Iowa Supreme Court says in this opinion, 1998 opinion.
And who's Walker up there? I see.
That's me. Our law does not appear to require, can you zoom up on that part? Our law here in Iowa does not appear to require formal administration of an oral oath. Hello? That's a misstatement. Can you put up the real deal? This is something that was in the books. It went ignored. Okay, they're writing, they're interpreting. Remember I said about a month ago, when we break the law, it's criminal. When they break the law, it's called an interpretation. Well, here's one of their breaking of laws. This is something that I didn't write. This is in the Iowa Rule of Evidence. This is a committee comment. The committee made the Iowa Rule of Evidence. Rule 603.
Case, they did not break the law on this paper here.
They misstated the facts and they broke the law. But they call it interpretation.
But this is the actual basic truth right here.
This is how they misstated the law. And you can see how these two statements cannot both be true. Anybody that has a basic understanding of right or wrong and can read these two different sentences, you got to let me read that first before you change that. I'll be quick, I promise. But now they went on to state in that opinion that the Iowa Code does not set forth the form required of an oath. Well, excuse me, this is on, as the lady was telling me at the state courthouse, she helped me find it. It is in the Iowa, it's not only in the Iowa Rule of Evidence, but it is in the Iowa Code. Page 267 and 268 of volume 57H of the 2003 Iowa Code annotated. She found it. It's in the code. Rule 603 is similar to 622 of the code by requiring the administration and understanding of an oath. An oath, administration, it requires administration of oath as predicate to competency. Well, what happened, Iowa Supreme Court? Can you guys read what's in black and white? I have brought this to the attention again of the Iowa Court of Appeals. I hope they don't miss it this time. They're supposed to decide the case on February 23rd. Iowa Court of Appeals case 03-11, or actually 4-862. It's referenced. It should be cited tomorrow. We'll be talking about this some more if you guys don't get it right this time. This is what we're talking about here. Cronyism, nepotism. It should not be that in the legal establishment that holds itself out to be so good, so righteous, so fair, a shining example to the world. We need the guy over here from the Philippines over here to go through and start getting some of these judges out of office, because it's not right. They got the guy over I guess the guy from the Philippines a couple weeks ago, as we reported, took out 56 judges. He just canned them, got them out of the office. Well, we need to get some of these judges out of office. I believe that Snell, he's already out of office. He's the one that authored that corrupt opinion. But there's a couple of the other ones that were deciding that case that are still in office. I believe it was also Larson and Lavarado. Okay, these guys are crooks. They need to be off the bench. They've got some problems here. They cannot read what's in black and white. And I'm here to tell you that you need to watch out for these fellas. I sat there at that oral argument yesterday. It appeared the whole time that Larson was basically arguing the same things that the prosecutors were, and he was helping the guy out when Justice Wiggins had one of the guys cornered on a specific point, such as, well, why can't the lawyers have a copy of their own statement? And the guy just sit there, Well, I think it was Larson that helped him out, and tried to argue that, well, we need to farm out this stuff, the ethical review of prosecutors to their cronies. And we don't need people that can't see right from wrong, who have no sense of spirituality or a sense of justice on the bench. These guys are basically in it for themselves, and they're not about just us, Justice. They're in it for just us, meaning them, Justus.
Right.
And that's all I have to say on that subject.
Okay. You referenced the ruling made by Judge Novak on May the 21st. This is a ruling that came as a result of a pre-hearing on May 21st, and March 21st, in which I set forth. No, it wasn't March 21st. It was May 21st. I'm sorry. I set forth a number of points in which the prosecutor had failed in this case, and one of those points was 2.54, the Iowa Criminal Code. And so he takes it up saying this. Next, the defendant maintains the complaint does not comply with Iowa Rules of Criminal Procedure 2.54, which requires that prosecutions for simple misdemeanors must be commenced by filing a subscribed and sworn to complaint with a magistrate or district court clerk or the clerk's deputy. Here the complaint was subscribed to by the deputy who arrested the defendant. The complaint was subsequently signed by District Judge Egley. There is nothing in the record, and the appeals court judge wrote that in his final ruling. There was no effort whatsoever to indicate or anything in the record that there was any subscribed to statement. So here we have several judges who are conniving conspiratorially along with the prosecutor to enter a simple misdemeanor when any one of them could have halted it. Don, let's go to that story. I don't know if we have in the few minutes remaining.
That's business as usual, as I would call it. They want to just go do business as usual.
Sure.
Rubber stamp, get the procedure going here.
That's right.
Finish it up. Go ahead and convict him.
Well, we want to thank you for doing some background work here, and we'll see you, I hope we'll see you a few more times here as you look into these things. I'd like to know what happens as a result of those oral arguments.
I'd like to make a comment.
Okay, Don?
Terrance told us that he saw Ann Danaher at the Capitol yesterday. And we've been talking about the county attorneys and complaints. Ann Danaher took on a case. She's a barber, and she took on the case and
Terry Harrington.
Yeah, Terry Harrington. And as a barber, she researched it and found the records that were hidden. And for the end result, she's not an attorney, but the end result, she saw that man after he was in prison for 20 years. And this was all taken care of by a county attorney in Council Bluffs. And the record shows that she dug up that the county attorney had done a lot of cases like this. And there, this guy spent 20 years before a barber finally uncovered the information. Okay. John, what do you want to do now?
No, we have that story that we neglected earlier about the...
neglected? Well, this is by Roger Munn.
Okay.
It just came out.
We may not be able to finish this, but go ahead.
And he says, The latest child abuse and neglect figures show that nearly half of all founded cases in Iowa involve children age 5 or under. This data underscores our decision to differentiate services depending on age and to pay particular attention to the little guys who are so vulnerable, said Wendy Rickman. Beginning in March, the DHS will offer services such as drug rehab or parenting classes or seek court intervention for all families in which there is a founded abusive child under age 6. In the current system, the families of about half of these youngsters receive less formal assistance. Little kids can't stand up for themselves, and so that's why one of our 3 main decision factors is age of the victim. The others are history of abuse and presence of risk factors like drug abuse or mental illness. In calendar year 2004, there was 12,920 Iowa children who were neglected or abused, compared to 13,288 the previous year. While the trend was flat over the past 12 months, the trend has been steadily upward for the last decade. Of the neglected or abused children, 5,994, or 46%, were under age 6. Another 3,765 were aged 6 through 10, and 3,161, or 25%, were aged 11 through 17. Last summer, the DHS announced that the department would concentrate its efforts on the most fragile families, where risk of abuse or reabuse is greatest. Lower risk cases will be referred on a volunteer basis to a private social work agency. The new design, called Better Results for Kids, will likely bring as many as 3,000 additional cases involving young children into the DHS, assuming current trends. I thought the DHS was already overworked. Here they're going to bring in 3,000 more.
I call that enlarging the borders of their tent.
On the other hand, the DHS will no longer open a formal case and coordinate services for this age group if there is no report of abuse or no founded report. In 2004, there were 2,300 of these cases. All but about 100 have been closed. Well, that's because a lot of them go into TPR, termination of parenting rights. Okay, John.
Okay, did you finish that article? I'm sorry. Go ahead.
Rickman said the focus on the youngest victims will make more resources available for all victims. Rickman said the new focus on most fragile families does not mean that the department will ignore other older children. John?
Okay, I want to thank you for that report, and thank you, Terrance, for those good reports from the court. I don't know if they're good reports. They're valid reports, and we'll see you next week.